Welcome, everyone, and thank you for joining us today for our program, International Trade Compliance, Due Diligence, and CFIUS. Next slide, please. My name is Larry Parker, and I'm the Vice Chair of our Corporate Section and Head of our M&A Group at Williams Mullen. I'm based in the Richmond office. Today, I'm joined by my colleague, Chris Skinner.
Morning. My name is Chris Skinner. I'm a partner with our corporate section in the international trade practice, and I'm based in our Tyson's office. My practice focuses on international trade compliance, including export controls, economic sanctions programs, customs and import compliance, anti-corruption, and CFIUS matters.
Next slide, please. Now, before we kick off, a few housekeeping items to go over. Submit any questions using the Q&A button that you can toggle to on the bottom of your screen. We will answer any questions, time permitting. If your question isn't answered during the presentation, we can reach out directly afterwards. If you have any audio or technical problems, please also use that same Q&A button, and our marketing team will get that resolved for you. And of course, you'll receive a copy of the presentation materials following the presentation later today. Next slide, please. So, Chris, what are the primary international trade compliance concerns in an M&A transaction?
Yeah. Well, when we're brought into an M&A transaction, whether it's on the buyer or the seller side of the deal, we're looking really to assess two things. One, if there are any steps we need to take to comply with any regulatory requirements before or after closing of the transaction. And then two, whether there are or there could be compliance issues that would impact the disclosures to the other parties and representations and warranties in the agreement, and ultimately the terms and potentially the value of the acquired business. So depending on the parties and the specific transaction, we are concerned primarily with these 5 areas of trade compliance: customs and import compliance, export controls compliance, economic sanctions programs, which deals with what countries and what parties they transact business with, anti-corruption concerns under the Foreign Corrupt Practices Act, and CFIUS notifications for transactions that could have national security implications.
So, Chris, before we go on, I used to think CFIUS was a disease. What does that acronym stand for?
Yeah, for the uninitiated, CFIUS stands for the Committee on Foreign Investment in the United States.
Okay, so Chris, why conduct due diligence for international trade compliance
Sure.
in M&A?
Yeah, well, the most obvious answer is successor liability. Generally speaking, an acquirer of a U.S. business is going to take on the liabilities of the acquired business that arise from past instances of non-compliance with trade regulations. And that can even apply in asset deals, depending on the scope of what is actually acquired. But there are other reasons too, which I alluded to earlier. Carefully tailored due diligence can help to identify undisclosed violations, and present an opportunity to account for risks of monetary penalties that could result from those violations, or even administrative penalties that could affect the future and viability of the business. In extreme cases, this can include things like revocation of export licenses or even suspension of exporting privileges. So in a lot of cases, violations discovered during due diligence can be handled through voluntary self-disclosures to the relevant government agencies, and there are opportunities to remedy past violations and strengthen the company's compliance program in the same course of action. Other reasons to perform due diligence for trade matters include identifying prior notification requirements, such as with a defense industry acquired company that might be registered with the Directorate of Defense Trade Controls, and you need to take steps to account for that current registration and transfer that to the new owner. It can also include, as we mentioned, CFIUS, where certain transactions might warrant notification or a declaration to the Committee on Foreign Investment in the U.S. to obtain a kind of self-harbor or clearance, safe harbor clearance of that transaction. I note also that for companies that are in the military intelligence space, semiconductor, or other highly controlled industries, or that conduct significant international transactions, due diligence can help to identify export licenses that might need to be transferred to the new company and avoid the blackout period that would occur while those licenses are in transit. And also to really do a kind of risk assessment and understand what the acquired company's risk profile is in the trade compliance area.
Chris, what does an international trade compliance plan look like? Next slide, please.
Yeah. Well, the scope and content of the due diligence that we would conduct on one of these transactions is really dictated by the acquired business and what its risk profile and international transactions look like. It's essentially the company's compliance risk profile. We tend to start off with a kind of broad-based survey of the business in the form of the usual due diligence questionnaires that most of us are familiar with. And then we proceed to get more specific based on the responses to those questions. And we're going to be looking at things like the international suppliers, the territories that they do business in. Are their products or services controlled under either the International Traffic in Arms regulations or the Export Administration regulations, which would raise the risk of compliance concerns depending on what their transactions look like? Who are their customers? And territories, and what markets do they serve? Are they industries that are subject to kind of heightened levels of scrutiny? We proceed then with like written questions and answers, interviews of relevant personnel, and that can be down to company engineers, that can be salespersons that are just most familiar with their customer base. Oftentimes, we'll be looking at specific transactions, running restricted party screening against their primary customers to ensure that they're not dealing with, even unwittingly dealing with companies or entities or individuals that are on restricted lists. And we're also going to be looking at transaction documents, whether there have been prior government inquiries or prior voluntary or directed disclosures to government agencies about prior violations. And of course, we want to see the company's compliance program documents to the extent they have them, so we understand how they treat their compliance risk.
Next slide, please. So what are some key considerations when we're looking at a CFIUS review?
Yeah. Well, CFIUS becomes an issue when the transaction falls within the committee's legal jurisdiction to intervene in the transaction. And this includes foreign acquisitions of control of a U.S. business, a quote unquote covered control transaction, as well as non-controlling investments in certain types of U.S. business. When we talk about these quote unquote covered investments, it's important to note that there's no minimum threshold for how much the acquiring company acquires. It could be a single, equity share that is, far less than what we consider significant in other contexts. What we're looking at is what rights the foreign person acquires in the U.S. business and whether the U.S. business is involved in certain critical technology, critical infrastructure, or they maintain or collect personal data of U.S. citizens that would raise the kind of national security risk associated with the transaction, potentially. In addition, under recent changes to the CFIUS rules, CFIUS can review purchases and sales or leases or concessions to a foreign person of covered real estate that imparts certain rights in that real estate. This includes property near sensitive military installations or critical infrastructure such as ports. So the first step is determine if CFIUS notification or declaration is mandatory in the transaction or voluntary. And then if it is voluntary, it doesn't merit because of its particular risk profile, a notification or declaration to CFIUS to, again, obtain that safe harbor determination that the committee is not going to intervene in the transaction. CFIUS can impose limitations on that transaction even after the fact. They can investigate a transaction that was not notified to the committee and unwind that transaction long after it's passed. So there's a real risk for not making a voluntary notification or declaration to CFIUS in those circumstances that do raise that kind of national security profile. It's also important, I'll note, to account for in the overall due diligence and transaction process, the amount of time it can take to prepare and submit a notification and to process that notification through CFIUS. Even if we, in a normal case, we might notify CFIUS of a transaction through a kind of draft or a high-level notification to the committee, to get their initial impressions before we actually submit that notification to start that 45-day clock running on CFIUS review. It's actually, for a full notification, a 90-day period. Sometimes they can be resolved in that 45-day notification period, but often CFIUS will direct an additional 45-day investigation period to have additional Q&A between the parties to the transaction and the committee. So it can require quite a bit of time to process and get all the way through to conclusion.
Chris, before we move on,
Yep.
does a voluntary submission to CFIUS limit the potential negative remedies following voluntary notification?
No, not necessarily, right? A voluntary notification to CFIUS could result in the committee determining that certain aspects of the transactions raise concerns, and the companies need to enter a mitigation agreement to limit, for example, foreign persons' access to critical technologies, things that are controlled for export purposes. And they might want other limitations on the rights that the foreign acquiring individuals or companies will have in the management of that company if it presents a legitimate national security risk.
Next slide, please. So what happens if we discover problems during this diligence process?
Sure. Yeah. Well, there are a lot of opportunities here and some good solutions. The first is voluntary disclosures, and this is the most common because in each of those areas that I mentioned, in import compliance, export control, sanctions, FCPA, there are opportunities to notify voluntarily the U.S. government that violations have occurred, and to, within a particular period of time, to investigate those, adopt remedial measures, and to get some feedback back from the government about whether or not there are going to be monetary penalties or other administrative penalties imposed as a result of those violations. By and large, except in serious cases, and certainly in willful cases that are more on the serious side of things, many voluntary self-disclosures result in either a warning letter or no action letter by the relevant government agency. So that can be a good way to clean the slate for the new acquired company. Other things, remedial measures, these need to be negotiated between the parties. They need to ensure that they've fully identified the nature and cause of the violation, and they've taken steps to ensure that those same violations are not occurring in the future, because otherwise you haven't really corrected the issue, and that's not going to help things from a compliance standpoint if you ultimately do need to submit a voluntary or, in some cases, a directed disclosure if the government becomes aware of the violations. Other considerations, closings can be made contingent on the seller taking certain corrective measures and making a voluntary self-disclosure and being financially accountable for the results of that disclosure. And of course, we need to account for all of these things in our reps and warranties, in the agreement, in the disclosure schedules for the agreement, and eliminate any ambiguity about how a responsibility for past violations are going to be handled between the parties.
Next slide, please. Well, I see that we don't have, oh, looks like we do have a question. Here it is. Are there some high-level due diligence questions that an investment banker should be asking its clients to screen for these issues? Good question.
Yeah, absolutely. And they really are going to touch on all of those core areas of trade compliance. I mean, we want to know about where their primary markets are for their sales and who their supply chains, what their supply chains look like in terms of who they're sourcing, raw materials, goods, finished goods from. And we really need to identify their overall risk profile. What countries are they dealing with, and what products are subject to these heightened levels of controls, whether because they're a military or derived product that's derived from a military product, or are they serving markets that are just subject to heightened export controls? Today, we think of the semiconductor industry having their supply chains run through China and other countries that are now subject to heightened export controls. We need to identify those and really vet what that transaction profile looks like.
Well, thank you so much, Chris. It looks like we're out of time. Thanks, everyone, for participating. If you have a question that we didn't get to or weren't able to ask, please feel free to reach out and we will respond later, and we will also circulate the materials after the closing of the presentation. Thank you so much. Have a good day.
Thanks, Larry.